Let's take a look at strikes from an employment law perspective. Perhaps the most highly publicized and dramatic manifestation of labor relations is the strike. However, despite the hold that strikes have on the public's imagination, the vast majority of negotiations conclude successfully without strikes. In a strike, employees withhold their labor, refusing to resume work until their employer agrees to more favorable terms and conditions of employment or refrains from engaging in unfair labor practices. Strikers are not quitting their jobs, but rather attempting to place pressure on the employer to act differently. Strikes and the threat of strikes play a vital role in negotiation. Because employees can credibly threaten to impose unwanted costs on employers through the disruption of production, employers have a strong incentive to bargain seriously, compromise, and attempt to reach agreement. Strikes can also impose costs and pose potential dangers for employees and their unions. There's no guarantees that strikes will succeed. Thus, the strike option gives both management and labor good reason to bargain seriously. Strikes and associated activities such as picketing are concerted activity. As such, strikers are generally protected by the NLRA, and private employers must not terminate employees for engaging in lawful strikes. Although the right to strike is protected under the NLRA, federal government employees do not have the right to strike. Many state and local government employees are also prohibited from striking. Strikers engaging in lawful strikes cannot be terminated, but they can be replaced. Economic strikes are undertaken to pressure employers to meet employee negotiation demands. The issues in dispute need not be money issues. Unfair labor practice strikes are undertaken in response to an employer's ULP, like refusal to bargain in good faith for the purpose of pressuring employers to comply with the law. In any strike, employers can cease operating or operate using management personnel only. If employers choose to use replacements for striking employees, the distinction between economic and ULP strikes becomes relevant. In economic strikes, employers can hire either temporary, for the duration of the strike, or permanent replacements. However, if the hiring of permanent replacements is motivated by a purpose prohibited by the NLRA, it is illegal. Strikers who are permanently replaced remain employees and have the right when the strike is over to be placed on a recall list, notified of available job vacancies, and rehired if possible. Strikers in a ULP strike can be temporary but not permanently replaced. Employers must reinstate unfair labor practice strikers who make unconditional requests to return to their jobs. Whether a strike is a ULP strike is not certain until after the NLRB has ruled. If the NLRB decides that a strike was responsive to an unfair labor practice, replaced strikers are entitled to immediate reinstatement and substantial back pay. At the same time, if employers confer permanent status on replacements in strikes that turn out to be ULP strikes, the replacement workers who must be discharged have grounds to sue for breach of contract. Strikers sometimes lose legal protection because of behavior they engaged in during a strike. In picketing, employees gather near the workplace and through words or signs make it known that they have a dispute with their employer. Picketing that restrains or coerces other employees who have the right to refrain from concerted activity is not protected and, under some circumstances, violates state criminal law. Mass picketing that does not allow picket lines to be crossed, actual violence or clear threats of violence against non strikers, destruction of employer property, and similar conduct are not prohibited. Picketing generally must be limited to the primary employer. Other secondary, neutral employers cannot lawfully be picketed. Under certain circumstances, employers can legally engage in a lockout of employees. Many work stoppages are, in fact, lockouts initiated by employers rather than strikers. Following the expiration of any labor agreement, an employer might choose to withhold from employees the opportunity to work despite their willingness to remain on the job and continue negotiating. The employer might do so because it fears that a strike will take place later at a disadvantageous time, or it might do so to put more pressure to settle on the union that it's reluctant to strike. Courts have allowed employers to use temporary replacement for locked out employees. Lockouts have become commonplace in professional sports. A lockout is illegal if the purpose of the lockout is to defeat employees' right to have a union.